you. Please be seated. Good afternoon, everybody. Welcome to the 14th Court of Appeals. We have one case on the docket. It is McCartney versus McCartney, number 14-24-310 CV. And we have counsel for the appellant, Mr. Powell.
Yes, Your Honor.
You're here and ready to proceed?
I am.
Okay.
Finally.
And Mr. Enos for the appellee, you're ready to proceed?
Yes, sir.
Okay. Then we will hear argument now in McCartney versus McCartney when you're ready, Mr. Powell.
All right, Your Honor. You know, obviously it's a privilege to be able to argue any case before a court of appeals. I'm 86 years old. I've been a lawyer 56 years. I've enjoyed every year of it. That said, may it please the court. This is my argument on behalf of Ashley McCartney, who is the appellant in the case. It really is a case that arises under the family code, so primarily that is the law that's applicable to the case. Thomas and Ashley McCartney were married on April 8, 2006. On June the 4th of 2020, they signed the marital property and exchange agreement. Mr. McCartney then filed for divorce on April 18, 2022. The applicable sections of the Texas Family Code begin with Section 4102 of the Code, which provides, at any time the spouses may petition or exchange between themselves all or part of their community property, then existing or acquired, as the spouses may desire. Property or property interest transferred to a spouse by a partition or exchange agreement becomes that spouse's separate property. Section 105 of the Texas Family Code provides that to promote amicable settlement of disputes in the suit for divorce or annulment, the spouses may enter into a written agreement concerning the division of the property and the liabilities of the spouses and maintenance of either spouse. The agreement may be revised or repudiated before rendition of the divorce or annulment, unless the agreement is binding under another rule of law. Section B of Section 4105 provides, if the court finds that the terms of the written agreement in the divorce or annulment are just and right, those terms are binding on the court. Section 3.409 of the Family Code provides the court may not recognize a marital estate claim for reimbursement for the payment of child support, alimony, or spousal maintenance. May I sit?
Please.
And the section that you wanted us to talk about, Section 3.410 provides that a premarital or marital agreement, whether executed before, along, or after September the 1st, 2009, that satisfies the requirements of Chapter 4, is effective to waive, release, assign, or petition a claim for economic contribution, reimbursement, or both. Under this subchapter, to the same extent the agreement would have been effective to waive, release, assign, or petition a claim for economic contribution, reimbursement, or both under the law as it existed immediately before September 1st, 2009, unless the agreement provides otherwise. Section 3104 was added to the Texas law by the legislature in 2001. It was amended in 2009. The effect it has on later cases involving premarital or marital contracts is to clarify that matters agreed upon in a signed agreement trump any argument about waiver, release, economic contribution, or reimbursement, or both, just as would have been true in cases before 2009. The effect that it has on this case is that Mr. McCartney has no valid claim for reimbursement of community funds belonging to Mrs. McCartney, with which he paid Mrs. McCartney's bills. Section 15 of the June 4th, 2020 McCartney Agreement states, Texas law, in effect, when this agreement is signed, controls this agreement and must resolve any disagreements about this agreement. On page 7 of section 19, subsection J, Mr. McCartney represents and warrants, I understand that by signing this agreement and accepting any benefit under it, I will be stopped from making any claim of any kind to any separate property or the separate estate of Thomas McCartney, except as provided in this agreement. And in subsection L, Mr. McCartney expressly states, I am executing this agreement with intent to be bound fully by all of its terms. Section 17 of that agreement sets out in bold print. Each party understands that by signing this document, he or she is permanently surrendering rights and claims he or she would otherwise have under Texas law.
Right, but aren't they agreeing to surrender the rights and claims as set forth in the agreement, or are you contending that it was the intent of the parties that this agreement fully supplant and replace all the whole body of rights under Texas law?
Basically, the substance under what we are contending is that when parties make an agreement like this, whether it's a Rule 11 agreement, whether it's a mediated settlement agreement, or even in a stronger case like this where it is a marital property exchange agreement, that agreement trumps anything else that may happen in the case. And I had the argument all written out. As you can see, I was reading from it. Basically, what the cases hold, starting with the Supreme Court, is that there is a difference between Chapter 8. Chapter 8 was, according to the Amman case, promulgated for the benefit of allowing trial courts to set spousal maintenance. But it is entirely separate from Chapter 4's law related to marital property agreements. In other words, once the people make an agreement, that agreement binds. And
okay, let me interrupt you for a second and ask you about that. Paragraph 2 states that the agreement will be effective after Ashley and Thomas sign it. So was it the intent of the parties that the property listed here, the two homes, were to become Ashley's separate property immediately in June 2020 when the agreement was signed?
that's what happened.
And that was the intent of the parties.
And that's what happened.
Okay, and under paragraph 7, Ashley is solely responsible for all debt associated with that property, and so that means, does it not, that Ashley was obligated from June 2020 forward to pay all the debt associated with those homes, correct?
except for the fact that the section that y'all wanted me to point out causes there to be a waiver of his right of reimbursement.
Okay,
Over
so.
and over has that language in it.
All right, so is it your position that even though Ashley agreed in paragraph 7 to be responsible for all debt, that if in fact she uses community funds to pay some of that debt after 2020, is it your position that Thomas has no recourse?
That's exactly right.
Okay, does that not mean that paragraph 7, that the promise in paragraph 7 is illusory?
Well, not necessarily, Judge, because if you go into detail on that agreement, it talks about that this agreement trumps everything else, any kind of other consideration. Now, as you probably already know, the trial court ruled that the money with which he was paying her debts was her money. So basically, she is paying her debts through him with her money, and that's our position.
I thought it was community money that was at issue.
It's community money, but she owns half of it.
Right.
Okay, so if it's a spouse buying something with his earnings for the wife that isn't just a gift, then the question is that his money or is it her money? And if it's still half the money, then he's buying it with her money. That's our position.
Wouldn't you then, if it is community property, why wouldn't you then allow the reimbursement to the community estate for that amount of mortgage payments and divide it?
Our feeling is that is finding that community property is a part of the estate. But if you look at section, I think it's the section right before y'all wanted me to look at it. The court may not recognize a marital estate claim for reimbursement for the payment of child support, alimony, or spousal maintenance. That's section 3409. And so our position is that what you have to do in these cases involving marital agreements like that, because of the litany of cases that follow, say you have to adhere to those things strictly. And when you adhere to it, then it is the same thing. In other words, it may be him paying with his earnings, but they belong to her. Therefore, he's not entitled to get back what belongs to her. That's our position.
Is it your position that by signing the marital agreement that Thomas releases any claim for reimbursement he may have on behalf of the community by operation of section 3.410, regardless whether the document itself says that he releases those claims?
And 3.409 also, Judge, and if you go through the particulars of the agreement, I think you'll find that that's what he agreed to do.
What language, what paragraph are you relying on for that?
Section 9 of the McCartney Agreement provides If the marriage between Ashley and Thomas ends by divorce, the parties agree that all community property, saving except tax deferred retirement accounts, shall be divided equally without regard to either party's separate property, earning ability, fault or breakup of the marriage, and these are key words here, or any other basis. That's what this agreement provides. Under Texas law, the trial court found that it is community property. Now, next thing is, during their separation, he brought in $750,000. And one half of that was $375,303.18, which belonged to her. So basically, when you take the sections of the family code and you apply strictly the agreement that Mr. McCartney made and this language of any other basis, then you get where he pays those bills with her money, then he's not entitled to reimbursement. So, does that answer your question?
I understand. Thank you. Your time is up for opening, so we'll hear now from Mr. Enos. Sure, please.
And please the court, it is an honor to be here. It's an honor to share the stage with this good friend of mine of so many years and think of all the fights and battles we fought against each other and with each other. I have three primary points I want to make. The first is, I think Mr. Powell is not grasping the actual nature of the reimbursement claim in this case. In this case, the reimbursement claim was not on behalf of either spouse, it was behalf of the community estate. And it's clearly authorized by law that you can pursue a reimbursement claim for the community estate for the payment of separate property debt and for debt secured by separate property. That is one of the specific types of reimbursement that the statute allows, and that's exactly what was done. And when the judge decided to honor those reimbursement claims, he put that back into the community estate, as the statute said, and then he did exactly what the marital property agreement did and divided it 50-50. So in this instance, it was working exactly as the statute envisioned. The second point I'd like to make is to point out that in the marital property agreement on paragraph 3, it says, regardless of what was discussed or previously agreed to, even in writing, this agreement is everything Ashley and Thomas agreed to about marital property. The significance of that is there's no other mention of reimbursement in this. This specifically says what's in writing is all we agreed to, and there's no mention of reimbursement claims in this agreement. I was frankly a little puzzled when you gave us the charge to look at 3.410. Now, I will admit, had I been in the legislature, I might have worded it a little more specifically, but you got to understand that this statute was enacted in its present form in 2009 when the legislature got rid of something called economic contribution and gave us back reimbursement claims. And so they needed to make clear that premarital agreements that predated that, because there was a period of time when there was only reimbursement, then the legislature created economic contribution, and then they gave us back reimbursement. They enacted this to make sure that everyone understood that a properly worded marital property agreement could give up those rights. It doesn't say, the statute doesn't say if they sign an agreement, it automatically gives away reimbursement claims. All it says is it's effective to waive them.
If it waives them.
Yes, and of course in this case it doesn't waive them. And if I'm a little unsure, but I think the argument from Mr. Powell is that the statute does just automatically waive it. But it's totally wrong to argue that just because me and my wife sign a marital property agreement that does not mention reimbursement claims, that means we waive reimbursement claims.
And
First
do
of
you,
all,
do you agree with him that this agreement, by saying it becomes effective when signed, means that the property in paragraph 5 immediately becomes Ashley's separate property, and she is immediately then charged with responsibility to pay for that debt going forward?
exactly, and that's why the exhibits that were presented to the judge at trial traced how much had been paid on the principal on those loans dating from the date they signed this marital property agreement. The reasons why 3.410 surely doesn't automatically give up your reimbursement claim is, first of all, Mrs. McCartney clearly thought she had the right to do a reimbursement claim because she asserted one at trial, and the trial court, his order said that the respondent's claim, and that was her, respondent's claim of reimbursement in the amount of $225,803.18 is denied. At least at trial, she thought this agreement allowed her to pursue a reimbursement claim. The second reason is it just doesn't make sense, because if my wife and I go married and we go honeymoon in Iceland and she buys a nice sweater and I buy an elaborate model of a Viking longship, and we agree on the flight back to make it our separate property, and I type up an agreement and we get it signed and notarized, making the ship model my separate property and the sweater hers, surely that doesn't mean that that also means she gives up any reimbursement claim. It just wouldn't be common sense. And then yesterday I found a case from the First Court of Appeals, to the extent their precedent sways us, from April 22nd, 2025, called Jimenez. It's a memorandum opinion 0123000087 CV.
We've read it.
Jimenez versus Jimenez.
Right.
And that was the exact same case. In that case, the husband appealed and said they didn't honor my reimbursement claim. Or actually, he appealed and said the wife should not have been granted a reimbursement claim. There was no specific provision in the marital property agreement. But he said, well, I think you could interpret it. And the Court of Appeals said that we got to construe these agreements in favor of the community estate, number one. And number two, this agreement doesn't even mention reimbursement. So we're not going to, there's obviously a reason why you're not going to get reimbursement. And you can see in a footnote that the husband cited 3.410, and it didn't help him in that case, and that was a very similar case. So if 3.410 doesn't automatically take away your reimbursement right just because you signed an agreement, if this agreement doesn't mention reimbursement, and in fact it says the only thing we're agreeing to is what's in this agreement, then he was entitled to pursue the reimbursement claim.
So I'll ask you what I asked Mr. Powell about paragraph 7 and Ashley's agreement to be solely responsible for all the debt. If she doesn't comply with that agreement, is that provision illusory? And if it's illusory, does that have any effect on the agreement?
Well, it could, but that would be one that we did not present to the trial court, and because we tried this case under the assumption that the marital property agreement was valid and enforceable.
Okay.
And so, in all candor, that was not an argument that we made.
But under his argument, there's no consequence for her using
Exactly.
other funds to satisfy those debts.
Right, and that was the exact basis of our reimbursement claim. We said, okay, if you're going to make this guy honor this extraordinarily generous agreement he got talked into signing, then you're going to pay the consequences for you not living up to it. And in this case, he used community funds to pay the debt for that was now her separate property, and we proved it with statements and testimony, and the judge granted it.
And that happened after June 2020, before
Yes,
the
sir.
divorce?
Yes, sir. And so that's why we think that the trial court acted totally appropriately. And I think, I'm not sure it's waiver per se, but I think it's really significant that she's making this argument now that, oh, no one can pursue reimbursement in this case, when that's exactly what she did in the trial case.
Right.
Court to the tune of $285,000.
So let me ask you a question about the decree and the reimbursement the language about reimbursement
Yes,
of
sir.
the decree. So I know Ashley's not necessarily challenging this, but could you walk me through the court's calculation of the reimbursement on this is page 35 and 36 of the decree?
Sure.
Like how did he arrive at these numbers, and then get to and then based on those numbers, get to the, basically the credit against the spousal maintenance amount?
Well, I think those are two separate things, but at least as far as the reimbursement claims, and again, I'm not always the best of getting into a judge's head and telling you exactly what he thought, but the evidence that we presented on the Concordia courthouse was that she had paid during that time, that the community had paid $161,899 towards reduction of the principal.
Okay.
So that's a clearly established reimbursement claim. And on the Telephone Road house in Milam, same thing in the amount of $55,478.
Okay, and then you have the two other numbers.
Right, and much smaller numbers, but in the third case, Mr. McCartney had paid two payments for her because she had stopped paying on the loan completely, which is a big deal for him because his name was on that loan at the time. And then the fourth one was, again, we don't have the record, but I was one of the trial counsel. There were some joint checks that were addressed to both of them that somehow were deposited or cashed by her, and that's what that $5,786 is. Then, if you want me to keep going down.
Yeah, so I mean, I'm trying to understand what the link is between those amounts of community reimbursement and the amount that the court credited in the next paragraph.
Where you're saying.
Am I reading the judgment right, where the court says that the balancing payment for the reimbursements from respondent's separate estate and the credit for the benefit described above shall be paid by
Right.
respondent by reducing the total spousal maintenance?
I remember what it was. So the judge was constrained by the fact that the marital property agreement required him to do a 50-50 property division, but because so much had been put over into separate property, once he granted the reimbursement claim, there wasn't enough to offset the reimbursement claim. So the only thing he could do was order Ms. McCartney to pay Mr. McCartney $150,000 as an equalizing payment. And if you look at the spreadsheet, that's the clerk's CR 197, which is Petitioner Exhibit 2, that's the spreadsheet the judge basically adopted as his ruling. The only way you could equalize it is say she owes him $150,000. And so what he did was he applied that $150,000 she owed him to the maintenance that was in the marital property agreement.
Yeah, so I'm trying to understand if the numbers for the reimbursement to the community, the four numbers that you just went through, total $225,000 and change. That goes to the community, right? That's a reimbursement to the community, and
Right.
then that would be split, presumably. Am I correct?
Well. So when the way we do it in a divorce case is the reimbursement owed to the community is one of the assets of the community. So we put it on the spreadsheet like you would a retirement plan or a house.
Okay.
So it's one of the assets, and then you total it down the column, and you see what the total is and how I'm going to divide it 50-50. And those numbers totaled up to a number that there wasn't. In some cases, if there's a reimbursement claim, the judge can say, well, okay, I'm going to give her more of your retirement account, and that's how we're going to make up this reimbursement claim. But in this
Okay.
case, there weren't enough assets to do it. And this judge didn't think it made sense to order a judgment against her for $150,000 while he's paying her maintenance and require him to do collection on the judgment and get the $150,000 back. So what he did was this offset.
Okay, so he took these four numbers, the 255 or 225, I'm sorry, in the reimbursement to the community. He added those into the community's column
Right.
of community assets, and then with some other stuff, and then split that And then as it turns out, sort of the bottom line was, he determined that she was gonna have to pay, or he would,
But she would have owed him.
she would have owed him $150,000 after he added up all the numbers and so
Right.
forth, and that was
And-
the division.
Right, and so this trial judge's somewhat ingenious way of doing that was, instead of doing a judgment against her, but he's paying the monthly spousal, give him a credit against the spousal. But now, that's, as far as I know, not one of the points of error raised in this.
It's not, but I was confused about that when I read the
Right.
judgment. I'm trying to understand how the reimbursement worked to the community.
Yes, there's a lot of what we do in divorce court that is confusing, but in this case, clearly, when we did the trial, even though you don't have the record, based on the pleadings, both sides thought reimbursement claims were allowed. That's why it's somewhat extraordinary to argue now that they're not allowed. And so,
Let me ask you about the supplemental findings. I'm sorry, the additional findings of fact and conclusions
Yes,
of
sir.
law that were filed in April later, after the decree. And so, I guess these were requested and proposed by Ashley,
yes, sir.
I'm assuming.
Yes,
And
sir.
paragraph 5 states that under the express provisions of section 3.410, that Thomas gave up his right of reimbursement he might have otherwise had, and so was barred from asserting a reimbursement claim. Does this conflict with the decree?
Yes.
Okay. Please continue. I'd like to have your complete understanding of why you think this conflicts.
I will tell you, we were quite surprised to see that those submitted sometime prior to it were picked up at some point and signed. And at that point, I'm not sure there was anything we could have done about it. But that's just not the law.
Well, does it conflict if the decree awards reimbursement to the community estate versus Thomas?
Well, yeah, that's one good point, and I think that's one of the things that is lost by the appellant. Reimbursement claims are not made on behalf of a party, husband or wife. They're made on the behalf of either his separate estate, her separate estate, or the community. And so he didn't have a reimbursement claim to waive. The community estate had a claim, and it doesn't say the community estate waived it, it says he waived it. And so to me, it's just kind of immaterial, because the judge didn't grant a reimbursement claim to Mr. McCartney, he granted it to the community.
And is it agreed that all the payments that were made on these houses after June 2020 were made from community funds? Or did Thomas make any from his separate property? It was all from community?
I mean, yes, it was from community, I'm telling you that, but we don't have the record in front of you for
Okay.
me to point to the court reporter's record and tell you that. But there was never any dispute about that, because everything they spent was what he earned during the marriage.
Does Thomas contend that any part of the marital agreement is ambiguous?
We made the painful decision at some point prior to trial to go forward assuming that the marital property agreement was valid and enforceable. So there may have been reservations, there may have been extraordinarily profound regrets, but we didn't make that argument to the trial court.
Okay. Thank you.
Thank you. It was an honor presenting to two of our three justices and our future justices.
And by the way, I didn't mention this before, but Chief Justice Christopher could not attend the argument today, but she is participating in the case and she will watch the argument, the recording of it, and she will participate in the decision. So it's not just two, there are three justices that will decide the case. But we appreciate your argument. Is there anything you would like to say in rebuttal? I'll give you a minute.
Well, I think you just made my point about the waiver. If the trial judge finds, as a matter of law, that he has waived his right of reimbursement, I don't know how the Court of Appeals can change that. waiver. And when you apply for 10 or 3410 and the agreement, I think you get the same result. But since I was late, I still wanted to address the other things in the court's decree that was added, never in the agreement. If you've read the briefs and the reply brief, you understand what I'm talking about.
Well, your time for argument is up today, but if you want to add something to the brief, you can file a supplemental letter brief to the court and we'll consider it.
Well, can I just file the written argument, the whole thing?
You can. Just mail it to the clerk and file it with the clerk.
Mail it?
Yes, or e-file it.
Email it in?
Yeah. Thank you. Thanks for your argument. The case is submitted. You're excused and the court's adjourned.
All rise.